Okay, guys, so we're going to go over chapters 8, 9, and 12 today, mainly regarding law. So give me 1 second. We're going to start right away. Go, Cam can join. Good. Okay, perfect. So let's go over chapter 8. Let's start out. All right, so the first thing we need to know is, what is a tort? Well, tort comes from wrong. It means to wrong somebody or cause injury to another person rather than a breach of contract. So we've mainly been discussing about contract law during our textbook readings. Now we're going to learn more about injury law. So this goes under liability. So a company gives a defective product and it injures someone, or a very famous example of tort law would be the McDonald's coffee case, where the woman spilled coffee on herself, got third-degree burns, and won a big lawsuit. So these are some examples of tort law. So let's keep going, okay? Let's go. There are 3 different types of tort. So you have your intentional tort. That means the person who did the injury intently doing it to you, hence why it's called intentional tort. A negligent tort means someone does something or puts you in a situation that, even though they didn't have a guilty mind, mens rea, they still put you in a situation that caused harm to you. That's negligent tort. And then strict liability tort occurs when a defendant takes an action that's going to be inherently dangerous, no matter what precaution the defendant takes. So let's say, for example, we're trying to bounce our head in a trampoline park. We hit our head and get a concussion. Or let's say we're trying to dive head first into a shallow pool and we hit our head. That would be under strict liability tort because we took an action that's dangerous and it can't be undertaken safely. So these are the 3 types of torts that we have in tort law. So an intentional tort. So for example, let's say I go ahead, Victoria, and I throw a rock at your head and you get a concussion. That's an intentional tort because not only did I have a guilty act, I also had mens rea. I did the act intentionally with intent to hurt you or injure you in some way. So therefore, an intentional tort would be hurting someone intentionally with a guilty mind. So there are 2 different types of intentional torts. One of them is assault. So an assault means you place one person in fear or apprehension of an immediate offensive bodily contact. So Andres, let's say I go to you and I say, hey, Andres, I'm going to beat the crap out of you, right? That would be a verbal assault. Let's say I don't do it. Let's say I'm just bluffing. That's still a verbal assault. So I put you in fear of offensive bodily contact. So that's what an assault is. We're not touching the person or harming them, but if there is a question of immediate bodily contact, meaning I'm threatening to hurt you, that would be under an assault. Now, battery, the main difference between assault and battery is assault is just saying it and putting the person in fear or apprehension. Battery is it actually happening. So let's say I say I'm going to punch you in the face, and then I go and punch you in the face. I'm going to be charged with battery. So that's just going to be an intentional, unwanted, offensive bodily contact. So next we have defamation. So defamation is essentially a publication or someone saying something, a false statement that's going to be harmful to your reputation. So let's say, for example, Victoria, I say Victoria is an animal abuser. That's going to be defamation because I'm going to assume that's not true, right? So if I make a statement, because let's be honest, animal abusers, their reputation is going to be really damaged if that gets out. Now, if I make a false accusation regarding that, that's going to be defamation of character. So that would be an example of defamation in the real world because this does happen. Now, let's say I broadcast that on social media. Let's say we have a deep fake of Andres, for example, or Cam. Let's say we make a deep fake of Cam. And it never happened. It's not true, and it hurts his reputation. Let's say I put a video or use AI to have him say something that he shouldn't say. That would be known as libel. So basically, it's defamation, but you just put it on a form of media, newspaper, article, could even be on social media such as Snapchat. So that would be an example of defamation. Libel is a form of defamation. So in the case of libel, we have general damages. So the victim is entitled to compensation for damages that flow from the defamation, but it is hard to prove. But if you can prove that there are harm to your reputation or financial damage because of the post, you can go ahead and sue and probably win in court. Now, we also have a difference. We have slander and slander per se. So this is another intentional tort. So slander, let's say I say Victoria, let's say I say Victoria has dementia. I know she doesn't have dementia, but let's say I say that, right? So that would fall under slander per se because it meets one of the four criteria. It means someone has a loathsome communicable disease. So Alzheimer's or dementia might fall under that. Let's say I say that Cam was committed a double murder yesterday. That would be a crime for which imprisonment is a possibility. Or let's say I say Andres committed wire fraud at his job. That would mean that imprisonment is a possibility, and that could also mean you're professionally incompetent. And then lastly, if a woman is unchaste, so if I say an underage girl is a prostitute, that would fall under slander per se as well. So it's basically saying something so bad that that they're going to be damages no matter what. There's no reversible way that there couldn't be damages. So the difference between slander and slander per se, slander lacks permanence, and slander per se is something so harmful that it's going to damage someone's reputation no matter what. We also have absolute privilege. So let's say, for example, I'm on the debate floor of Congress, and I say something that might not be entirely true. Let's say I say something about Congressman. Let's say I say something about Chuck Schumer on the Senate floor, right? Chuck Schumer is a senator for the state of New York. Let's say I say Schumer passed his bill when he didn't. He can't sue me for defamation because I have absolute privilege when I go on the floor. So absolute privilege means that no matter what happens, you can't be sued for defamation for any false statements made. It's very rare, but the debate clause in the Constitution grants those that speak on the Senate floor to be granted this privilege. Very rare, but it does exist, typically in Congress or the Senate. And then we also have conditional privilege. So let's say, for example, I testify in court against Victoria. Let's say Victoria punched my sister in the face, right? Now, if I go and say, hey, Victoria punched my sister in the face and then spit on her, am I make that let's say she didn't spit on her, right? So I could still be protected under conditional privilege if I didn't do that intentionally to harm her reputation. If I did that just to prove something in a court of law and there was evidence to support that, then I couldn't be sued for defamation. But if I made it with actual malice, so let's say I say, hey, she punched my sister and she tried to burn my dog, right? Let's say that's not true. I'm just saying that to try to ruin her reputation even more. That's going to fall under actual malice, and I can actually be sued for that defamation. So that would be an example of conditional privilege. So with actual malice means I have to know that it's not true. So I let's say I know it's not true that she was going to burn my dog, right? That would fall under actual malice. If I didn't know it was not true, it's not going to fall under actual malice because I didn't intend for it to hurt. Okay. And then we also have the public figure privilege. So the public figure privilege means we're not going to hold people liable for making false statements about them as long as the statements were not made with malice. So let's say, for example, let's say I say Joe Biden has dementia. Now, I don't know if he has dementia, right? But let's say I say that. if I know, we don't know if he has dementia or not. That's a question, a fact, right? But let's say I say, I don't know, let's say, trying to think of some type of celebrity out there. Let's say I say Kim Kardashian has dementia. I think we know pretty well that Kim Kardashian doesn't have dementia, or Pete Davidson, right? So if I say that and I know and I have evidence that they don't have dementia, but I say it anyway, that statement might be made with malice, and I could actually be sued for that. But but if I don't make the statement with malice, I'm not going to be charged. And the reason for that is because the public figures have such a big platform that they can simply defend themselves pretty easily in the eyes of the people. So that's why the public figure privilege exists. We also have false light. So let's say we go back to the animal abuse example. Let's say I say Victoria abuses animals. So that's going to create false light around Victoria. People are going to think she's a monster. They're going to think that she's a horrible person. That's going to create false light. So it's basically attributing characteristics or beliefs to a person that the person does not possess, or creating the impression that an individual has taken certain actions the person has not taken. So if I said that she did that, that's going to create a false light around Victoria as a person. Then we also have public disclosure of private facts. So let's say, for example, a good example of this would be Johnny Depp and Amber Heard. So in that case, which was publicized, they talked about their sexual relationship with one another. That's typically something that's a private fact, but they exposed it to the public. So that would be an example of public disclosure of private facts. So we also have what's called appropriation for commercial gain. So let's say I own a store that sells sports equipment. Let's say I specialize in selling basketballs, and I put a figure of LeBron James on the front of my store saying, "Hey, go buy my basketballs." Well, that would be appropriation for commercial gain, because I've not gotten consent from LeBron James to go ahead and use his likeness and image to sell my products. So I could actually be sued by LeBron James and his lawyer for appropriation for commercial gain. And then we also have an intrusion on an individual's affairs or seclusion. So all this means, let's say, for example, I go into somebody's house, let's say someone who I'm testifying against, and I and I wiretap their house, or let's say I hack into their email to get evidence to support my case. That would be an intrusion on individuals' affairs or seclusion, because I didn't get consent to do that. We also have false imprisonment. So false imprisonment, it can be a little confusing. All false imprisonment is, it means it's either being physically restrained or the threat of being physically restrained from a dwelling. So that means someone has, let's say you tie someone to a chair in your bedroom, let's say you pin them against a wall, or you threaten to tie them up, or you don't release their property. So let's say, for example, you say, "Hey, I'm not going to let this let your dog go." That could be false imprisonment of the dog, but it can't be under moral pressure. So let's say, for example, you're at work and your boss tells you you're a horrible person, or you're going to be one of our worst employees if you don't stay late tonight. So that is a moral threat, right? But if he said, "Hey, you're not leaving no matter what, unless you work late," then your boss could be charged with false imprisonment, because he made the threat to release you, or threat to use immediate physical force. Say, "You're not leaving, or else I'm going to pin you to the wall." So we also have intentional infliction of emotional distress. So this is very hard to prove in a court of law. But let's say, for example, I say, "Cam, your mother's had a heart attack and she's in the hospital." Let's say that didn't happen, and I know it didn't happen. So I made a false statement with intent, right? Let's say during that time you injure your leg or you bruise yourself, right? You get some type of injury to you. Or let's say you can't sleep for the next couple of days. You get high blood pressure. You have to prove that you had that in order to for the defendant to be charged with intentional infliction of emotional distress if you were the plaintiff. We also have misuse of legal procedure. So we also have malicious prosecution and wrongful civil proceedings. So let's say, Victoria, let's say you're accused of stealing from cash register of the store you work at, right? But it turns out you never did that. Let's say there was no evidence and the court made such a bad decision that they could argue for malicious prosecution. So you could appeal your case for malicious prosecution and possibly win. So that would be an example of malicious prosecution. So it's basically, hey, I was in jail or I had to be on probation, night job, and I want to recover my lost wages or I want to sue for punitive damages. So that would be an example of malicious prosecution and tort use of legal procedure. Make sure. Okay. We also have an abuse of process. So let's say, for example, I want to get a divorce with my wife. I hope it never happens, but let's say it happens. And let's say I don't want to pay alimony to my wife. And I say, hey, me having to pay alimony is hurting my reputation at work. But if you don't make me pay alimony, then we're good. And I won't sue you for defamation, right? I won't sue you for slander or defamation. I can't do that because it's an abusive process. Because legal proceedings for slander are not intended to be used as a mitigating device for a divorce dispute. So we also have a trespass to realty. I think you guys could put together kind of what that means. It's also known as trespass to property. So all that means it has to fall under a certain amount of criteria. Number one, you enter a land of another without permission. You cause an object to be placed on the land of another without the landowner's permission. You stay on the land of another when the owner tells them to depart, and you refuse to remove something you placed on the property that the landowner asks you to remove. So let's say, Anthony, for example, let's say I decide to let's say I put a big boulder on your property and you tell me, hey Jared, I want you to remove that. I want you to remove that from my property. Well, let's say I say no, I won't do it. You could go ahead and sue me for trespass to realty, real property, because you told me to remove the item and I refuse to remove it. So that would be an example of number 4. But I can't argue, hey, let's say I was landscaping for his property and I put it on, or hey, I didn't know this belonged to him and we had a job to put a boulder on a property. That I can't use as defense because I was intentionally being on that plot of land. So trespass to personal property, meaning that you're temporarily exerting control over another person's personal property or interfering with the owner's right to use it. So let's say, for example, Victoria, I go to your garage and I try to steal your bike, or let's say I steal your bike, but it prevents you from going to work and making money. Well, you could sue me for trespass to personal property. Or let's say, for example, I take the bike and then I break it. I could sue for damages and the repairs needed for the property and lost wages that might have occurred because I couldn't travel to work. So we also have conversion. So let's say, for example, I take someone's briefcase full of drugs by accident. I try to get through airport security and they catch me with the drugs, even though I did not intend to have them. I could still be charged with the crime of conversion. So if I have possession of stolen goods, right, that would still result in conversion. So let's say a company stole a car from a parking lot and they sell me the car. I would still be charged with conversion because I'm in possession of a stolen item. Because it states Therefore, buying goods in good faith without knowledge of any impropriety also is not a defense. We also have a private nuisance. So let's say, for example, Anthony, let's say I throw a party right next to your house. Let's say you have a baby daughter and the wife, and the baby's trying to sleep, and my partying, and let's say I have a crazy party and I have a water park in the back and it starts to flood your backyard. You could sue me for a private nuisance, meaning that I'm endangering your property, safety, or welfare of the community. So let's say with my loud antics, I'm disrupting the community's welfare and their mental health. They could sue me for a private nuisance in a court of law. So we also have disparagement. So disparagement is very, very similar to defamation. So this one, disparagement would be regarding a property interest. So let's say, for example, let's say I'm trying to think of a good example. So let's say, for example, I say, hey, this person's workout program didn't work well for me. Or let's say, hey, this person had this vaccine that I thought would work for me, and I got side effects that they didn't tell me about. That could fall under disparagement because I'm not trying to harm their reputation, but I'm trying to harm their product and service. So that would be an example of disparagement. It could happen in medical malpractice when side effects are not openly stated to the plaintiff. We also have slander of quality. So let's say, for example, regarding the product, let's say I just say it, right? I tell my friend, hey, this vaccine didn't work for me. I got sick from it. I'm going to sue. That would be slander of quality. Let's say I put in an article, or let's say I even posted on Twitter that this vaccine doesn't work. I could say, hey, this doesn't work. And let's say there are side effects. Or let's say they did tell me the side effects, but I didn't care and did it anyway. That would fall under trade level because what I say is not true. And let's say it's related to the ownership of the business property. So let's say I said, hey, the medical office that they own is really run down, and the property managers are drug dealers, right? That would be slander of title. And then we also have food disparagement. So let's say, for example, I go to a restaurant, and let's say the restaurant doesn't provide me great service, but let's say the food's good. But let's say online, I write a review saying the food is horrible. I will never eat here again. There was mold in my food. Let's say we had mold in our food. I don't know how, but let's say we do. Let's say that wasn't the case. The restaurant could sue us for food disparagement, also known as veggie libel. Or let's say, for example, we sell 1,000 pounds of ground beef to a meat manufacturer or someone that's going to turn it into sausage or something like that. Let's say they make beef sausage, right? And let's say we know there was E. coli in the beef, but we made a statement saying there was no E. coli. We checked, and then people go and get sick. The company that we sold it to, let's say Sausage Makers Inc., can sue our company, the company that supplies the ground beef, for food disparagement. We also have intentional interference with contract. So let's say, for example, someone tries to, let's say we have a loan, right? Let's say we have a private loan with a company, and we say, oh, they never loaned me the money. I don't have to pay it back. Let's say I go and say that online. Or, yeah, let's say I tell another company that. So let's say I get sued for putting that out there, saying that there was no loan to begin with. So let's say we get sued. The defendant in the case, right? We need to prove a valid and enforceable contract between the two parties existed. So let's say we signed a promissory note with a clear term sheet. The defendant knew of the existence of the contract and its terms, which we did. We intentionally undertook steps to cause one of the parties to breach the contract. So let's say we were able to pressure them and maybe get them to try to break the contract, and then the plaintiff was injured. Let's say they had reputational damage because of it. Or let's say we were saying they were charging a 35% interest rate when they were charging 7. So that could be an example of intentional interference with contract. So we also have unfair competition. So let's say, for example, we have a monopoly. Let's say Standard Oil. Back in the early 20th century, Standard Oil was a huge oil company that owned everything. Because of this, they were able to set whatever prices they wanted because they had no competition. So because of that, well, that would fall more under monopoly. A better example. So let's say, for example, someone owns a jewelry store, Ali, right? And let's say Mark sets up a jewelry store not for the purpose of selling jewelry, but to try to get Ali out of business. He can't do that. So that would be an example of unfair competition. Okay, I want to be able to get through this, but we also have chapters 9 to go through as well. So we're not going to be able to finish up chapter 8. If you guys want to finish up chapter 8, let me know and we can do an individual session for that. But I don't think I'm going to have the time. Very sorry about that. So let's do chapter 9. We have negligence and strict liability. So negligence is just a behavior that creates an unreasonable risk of harm to others. So this is not intentional, but let's say we create a product, the product is defective and someone gets injured. That's going to be negligence on our company. Now, let's say, for example, we're driving on the road and then we have a heart attack on the road. Second, someone's trying to join our meeting. Okay, good. So let's say we're on the road and we have a heart attack on the road and we crash and we cause property damage or we crash into someone's car. We're not going to be at liability or at fault and having to pay damages because of an unfortunate accident. But let's say we drank 10 Red Bulls, or another example. I don't know if you guys remember. You remember the episode in Family Guy where Peter goes to McBurger Town and he has a stroke after eating 20 hamburgers? I think you guys if you guys watch Family Guy, probably remember that, where Peter had the stroke and he sued McBurger Town and McBurger Town won. Well, I think there could have been warning signs that he could have gotten sick if he ate 20 hamburgers in one sitting. So Peter likely tried to sue McBurger Town for negligence, but because he engaged in an act that could get him sick if he overate so many hamburgers, Peter's case would be thrown out of court and dismissed, and McBurger Town Industries would win. So that would be an example of a negligence lawsuit in the cartoon world, not in the real world. Okay, perfect. So we also have the reasonable person standard. So all this is, it basically sees, okay, what would a reasonable person do in this situation? A normal member of society. So let's say, for example, we own a doggy daycare business, and let's say we're distracted or we have other dogs to watch and we accidentally leave a dog outside, right? Let's say the dog, let's say, for example, the dog is a pug. Pugs can't be outside for too long. They can overheat very quickly. Let's say the pug overheats, passes out, and he has to go to the hospital. I could make an attempt to sue the doggy daycare for negligence, right? So let's say we want to do a reasonable person standard on the owners or the people that were supposed to watch the dog. So we need to know, okay, how likely was it that the harm could occur? Did I tell the doggy daycare people, hey, my pug cannot be out in the sun too long or else he will pass out and go to the hospital? So if I said that and there's proof that I said that harm, that's number one. And then number two, how serious is the harm? Well, if the pug is going to go to the hospital, it's pretty serious. So that fulfills number two. Number three, how socially beneficial was the defendant's conduct that posed the risk of harm? So did them leaving the dog outside, was that more beneficial than watching the other dogs? Let's say the other dogs were inside, they had food and water, and they couldn't get sick. So number three would be fulfilled. And then number four, what cost would have been necessary to reduce the risk of harm? Well, putting more attention on my dog would probably reduce the risk of harm. Okay. Okay. And we also have breach of duty. So let's say, for example, the responsibility of the doggy daycare is to watch the pets and make sure they're taken care of. My dog not being watched and taken care of is a direct breach of duty. And then we also have causation. So we have breach of duty, we have duty. So that means the standard of care that they need to have, right? So let's say they need to watch my dog, right? Because they're a doggy daycare. And let's say they fail to live up to that. We also have causation as well. So there's two different types of cause. You have your actual cause. So that means that the defendant's breach of duty directly resulted in the injury. So let's say, for example, my dog got injured directly because um, the my pet was not being watched. So that would be an example of actual cause. But let's say, for example, let's do a different example. Let's say proximate cause, right? Let's say I'm driving a car and the tire blows off, my car crashes, and I break my arm. I can sue the company that made the tire for a defective tire. But let's say, for example, we're on the road, or let's say we have a machine, right? And the machine breaks, and let's say the machine is making spikes, right? Let's say the spikes injure me, and then they go ahead and they destroy a window of the person next door. The person next door can't sue for damages because of proximate cause. So only the person that's directly affected, meaning myself, the defendant, can sue, because that would be highly unusual to happen. So here are different types of damages that we could take. So we have compensatory damages, pretty self-explanatory. Damages related to compensation. So if we have proof that we lost wages or lost money due to a damage, or we had medical expenses or something of that nature, we can go ahead and sue to reimburse our losses. And then we also have punitive damages. So let's say we didn't lose money, but let's say we want to prevent this from happening to anyone else. We can sue on the premise of upping a company's safety standards, or even punishing the company with some type of probation, or prohibiting them from using the piece of equipment again. So that would be an example of punitive damages. So compensatory means to get financial reimbursement. Punitive means to make sure it doesn't happen to anyone again. And then we also have a concept called res ipsa loquitur, which means the thing speaks for itself. So that means the defendant's negligence was the cause of the plaintiff's harm, even though there's no direct evidence. So let's say, for example, there's a case here with Bonacci versus Brewer Service Station, right? So let's say, so in this case, right, we bring a vehicle to a service station because of a strange noise. Now, in the service station, there was a sign saying, "Do not stand near the vehicle bay." And the one of the employees directed Bonacci right to the vehicle bay. That way, Bonacci could show him what happened. Well, do we know the Jeep falls off the bay and it injures both of them? So Bonacci sued the service station under res ipsa loquitur, because even though it wasn't his fault, he was still directed anyways towards it. So that means the defendant's negligence was a result of the plaintiff's harm. So let's say the employee's duty is for them to make sure that they follow the rules of the shop. And let's say there was a big sign on the wall saying, "Do not stand near the bays," but the employee led them near the bays anyway. That would be a breach of duty, and therefore Bonacci could win the case. So that would be an example of res ipsa loquitur. We also have negligence per se. So let's say that means the defendant violated a statute and acted to prevent a certain type of harm. So let's say, for example, we have a shop that sells alcohol, right? And let's say by accident we sell alcohol to a minor, and the minor goes out, crashes their car, and hits somebody and injures them severely, which could be constituted as vehicular manslaughter, right? we could be sued with negligence per se because we sold alcohol to a minor that caused another crime. So that would be an example of negligence per se. We also have dram shop acts. So let's say, for example, I own a bar and there's a guy that has maybe had 3 drinks and then my bartender serves him another 8 drinks because he's paying a lot of money for them. Yeah, we're making money, but let's say the plaintiff gets really drunk. They're stumbling outside of the bar. They fall and hit their head and they have to go to the hospital. Under dram shop acts, if the state has dram shop acts, they could sue us under that in order to get damages, whether that be for medical expenses or lost wages as a result of having to be in the hospital. So that would be an example of dram shop acts, and that applies to bars, and it can also apply to homeowners. So let's say, for example, we have a beer pong party, and someone drinks too much, and they collapse and they hit their head on a tree. Well, they could sue us under dram shop acts because we knew they were drunk, but we didn't do anything to stop it. So each state's going to have a different type of negligence. Some states have the same, but states' negligence policy is a little different. So a lot of states have phased this out, but we have what's called contributory negligence. So that means the defendant and plaintiff are both negligent. So let's say, for example, we have a car company, and let's say the tire on the car is defective, but let's say the plaintiff was drifting all over the place going 110 miles per hour. That would be an example of contributory negligence if both parties were at fault, us for making a defective tire and then the defendant for going over the speed limit and recklessly driving. And we also have a concept called the last clear chance doctrine. So all this means, let's say we're riding our bike on A1A and an old lady comes in our way. We crash into the old lady and we break her hip. So we could, let's say we try to argue in court and, hey, the lady could have moved out of the way. But because of the last clear chance doctrine, the lady could still sue regardless because that doctrine protects the lady from that argument from the defense. So that would be an example of that in place. So we also have a peer comparative negligence. A lot of states have implemented this. So all this means it's a percentage of fault of the defendant. So let's say, for example, both parties are at fault in some way. Let's say we own a construction company and we have a crane that crashes and injures one of our workers, and we have a workers' comp injury case, right? And let's say the defendant, the plaintiff in the case, the construction worker, let's say his name is Mark. Let's say Mark doesn't wear a hard hat on the job site, even though they clearly marked that he needs to wear a hard hat. But let's say we also had a faulty crane that wasn't properly inspected. So each of us will be liable for damages in some way. And then we also have modified comparative negligence. So it's basically the same thing, but in order for the defendant to win damages, they must be more at 50% at fault before the plaintiff can recover. So let's say the construction company is a defendant and we're 60% liable. We have to pay 60% of the damages to the plaintiff. But let's say we're 30% liable, we don't have to pay anything. In each state, some states have modified comparative, some states have peer comparative, and some states have contributory. So each state has adopted at least one out of the three. And then we also have a concept called assumption of the risk. So have you guys ever been to a trampoline park and you have to sign a waiver before going on? Well, that would be an example of assumption of the risk. That way, if you get hurt, you can't sue the park. Okay, so I want to get to a little bit of intellectual property because there's a lot in that chapter. Okay, so we have intellectual property. So intellectual property, so we can own real estate, we can own chairs, this is our property, right? As long as we own it in our name. Intellectual property comes from someone's mind. So that can be an invention, it can be a logo, it can be a slogan. So for example, better ingredients, Papa John's. I think better ingredients, better pizza, right? That's trademarked. That's trademarked by Papa John's. So that represents a mark, word, design, or picture that a product uses to identify with the producer. So let's say we stay like a good neighbor, State Farm is there. That I assume State Farm has trademarked that. That way no one else can use it. So that would be an example of a trademark. We also have trade dress. So let's say you guys have had a Coca-Cola bottle. It has a signature hourglass shape, and then it has the red branding on it. That would be example of trade dress. So, and also an iPhone can be an example of trade dress. So here's my iPhone. It's clearly got this shape, this rectangle-like shape, and you can clearly recognize that it's an iPhone over an Android. So that would be an example of trade dress. So in order to meet the qualifications for trade dress, the trade dress has to be primarily non-functional. It has to be inherently distinctive, and the infringement needs to create confusion. So we also have a concept called trademark dilution laws. So that means that's going to prohibit the use of distinctive, famous trademarks such as McDonald's without showing consumer confusion. So let's say I open a restaurant called um, Mick. I'm trying to think of a name. Let's say I name it McLeo's, right? Now, if I do the same M that McDonald's has, that's going to fall under a trademark dilution law because that might confuse customers. They might think my place is McDonald's. Okay. So the difference between trademark is more of a slogan or a thing, right? A copyright is an idea. So that can be a book, that can be a music video. Have you guys ever seen on YouTube a video got banned or demonetized because of copyright infringement? Well, let's say we used a song from Jay-Z in our whole video. Jay-Z's record company or whoever owns the copyright can request that we take down the video due to copyright infringement. So that would be an example of an artistic work, a musical artistic work rather, being protected under copyright. So we also have the fair use doctrine. So that means, for example, let's say we have a book written by Tucker Carlson, and MSNBC is trying to do a piece on Tucker Carlson. And let's say they take an excerpt from his book, say, and let's say he said something not so great. That would They could do that under the fair use doctrine and not get sued for copyright infringement because they're using it for research and criticism and news reporting too. So it would fall under the three. Therefore, they could use the fair use doctrine. And we also have a patent. So a patent, let's say I invent the iPhone, right? Steve Jobs created the patent. Let's say he had the patent for the iPhone. That means no other company or person can create iPhones. That would be illegal and violate the patent. Or let's say, for example, I invented this fob, and no one else is allowed to use it. I could create a patent for the fob. So that would be an example of a patent. Now, there's two type of arrangements that you can have. You can have a tying arrangement. So let's say my company, Fob Manufacturers Inc., I'm the only one that's allowed to make that fob. And let's say I put a tying arrangement in my patent. But let's say I have another company called Titan Fobs Corporation, right? And let's say, hey, you guys are allowed to make my fob as long as you pay me a royalty, right? But you're not allowed to let anyone else do it whatsoever. So that would be an example of cross licensing. So I could say, hey, you have the right to manufacture my product with my design. You have to pay me a royalty though every month on the sales, and in addition to that, you won't be able to let anyone else manufacture it. So that would be an example of cross licensing. So we also have a trade secret. So, for example, KFC's chicken recipe, that's an example of a trade secret. So that would be a process, product, or method of operation that gives a business person an advantage over their competitors. So let's say, for example, the Krabby Patty secret formula. Plankton is always trying to steal his trade secret in order to increase the profitability of his restaurant, Chum Bucket. So he's trying to get a trade secret from Mr. Krabs regarding his product, the Krabby Patty, and his process in order to make a Krabby Patty. So that would be an example of a trade secret. Now, Mr. Krabs, he could sue Plankton for trying to steal the secret formula. So that would be an example in the cartoon world. So so Plankton would not win the case because a trade secret existed. So the Krabby Patty secret formula, Mr. Krabs safe, it actually exists. The defendant tried to acquire it through unlawful means, so he tries to break in to the Krusty Krab every time, and then the defendant uses the trade secret without the plaintiff's permission. So he tries to use the Krabby Patty secret formula to go ahead and make the chunk bucket better. Okay, so that is regard the key terms regarding chapter 12. So let me try to finish up more of chapter 9 as well. Okay, keep going. So let's go back to chapter 9, okay? Okay, so we also have what's called Good Samaritan statutes. So let's say, for example, we tell someone, hey, don't go to this trampoline park or else you're going to get hurt. Or let's say we tell, trying to think of an example, we tell someone on a ride, hey, you shouldn't go on this ride. I recommend you don't do this because you can get sick. And let's say we get sick on the ride and we have an epileptic seizure. Let's say we have an epileptic and they go on a ride, and the guy, before going on, he warns them, hey, I don't recommend you go on this because you have epilepsy. And let's say we do it anyway. We would not be liable because of the Good Samaritan statute, because we were trying to remove the threat of liability from the person with epilepsy. So we also have strict liability. So that's liability without fault. So let's say, for example, someone is driving a truck, right? Or let's say you have someone using a piece of machinery and the person is misusing that machinery. Let's say they're trying to put their finger in the slot where you have to do a piece of metal, cut another piece of metal, and let's say they get their finger chopped off and they sue the company for negligence. Well, they wouldn't be able to do that because it involves the risk of serious harm to people or property. It's so inherently dangerous that it can't ever be safely undertaken. And it's not usually performed in the immediate community because people are not usually putting their finger in metal cutters, right? It can't ever be safe to put your finger in a a metal cutter, and it can cause serious risk of harm to people or property. It's going to cause serious harm to you. So therefore, that would go under strict liability, and that's liability without fault. Okay, let's go back up to chapter 8. Okay, so we have, what do I not go over? Okay. unfair. Okay. So we also have fraudulent misrepresentation. So let's say, for example, a party in a court of law says, "Hey, they tried to destroy my house." Let's say it never happened. They did that with intent in order to gain personal gain. Let's say we're in the state of Idaho and they're filing a lawsuit against someone stating that they caused damage to their house and they want to take their house in order to pay for the damages. So let's say we have in rem jurisdiction, right? So let's say they do that in order to gain the money from the sale of the property. So that would fall under fraudulent misrepresentation, which is using intentional deceit to facilitate your personal gain. So we have compensatory damages. We already went over it. It's just to compensate financially the victim the harm the victim received during the crime. And the person that is hurt is called the tortfeasor. So we also have nominal damages as well. So let's say someone is suing a company for $1,000 because of a injury or something like that, and the defendant doesn't want to deal with all the legal fees and everything like that. They could pay out a nominal damage in order to cover out the court costs. And we also have punitive damages. We already went over that, but to go over one more time, it's basically we're just trying to prevent the same thing from happening again. So we could ban a use of equipment or something of that nature. Okay. And we also have, that's it for chapter 9. Let's see if we can get anything more out of chapter 8. Okay, that was chapter 8 and chapter 9. So I can go over a particular case. So let's take a look at. Let's try to get a good case here. Okay, so here, example, Mazda Motor Corporation versus Hearst. So a 16-year-old was driving a Mazda, and then the car lost control and spun out, right? So one of them died, right? And the parents are suing Mazda, saying that the vehicle was negligently designed. So the Hearst won the lawsuit for the following reasons. So let's take a look at the case. So let's take a look. So we see here the plaintiffs demonstrated that it would not have been difficult to avoid the defect found by the jury that caused the fire, right? So this was also proven with multiple other models. This might not have happened with other models, but more specifically the Mazda 3. So they contend that the jury's punitive damages are not going to relate to any civil penalty. This is like my favorite part. I'm in here all the time. So all this means, right? Excuse me about that. Let me just get back to. I don't know why this went out. Let me just get back to the textbook. 1 second. About that, guys. Okay. There we go. Okay. So in this case, because the vehicle was seen to be defective, meaning it caused fires, the plaintiff, the Hearst, won the case and won a significant amount of money. So that's pretty much it, guys, for 8, 9, and 12. So if you guys want to go over more regarding some of the cases in there, or just want to get a better idea of the concepts itself, you can go ahead and book a private session with me just to get a better idea and answer any specific questions you might have about other chapters, because we weren't able to fully finish up 1, 2, and 3, along with 4, 5, and 7. So if you guys want to clear some things up, especially for 1, 2, and 3, you can go ahead and sign up for a personal session with me if you would like.
Thank you.
No worries, guys. All right,
Yeah, thank you so much.